It's terrific to be back with all of you here on August 22nd. We are in the midst of summer and it is beautiful where I am. I'm hopeful the same for all of you. We know, of course, that there has been some devastating weather in various corners of the country, particularly in the West. And so for any of you who have loved ones out there or who may be tuning in from out there yourselves, know that we're thinking of you. And we have a full program today that we would like to walk you through. So let me give you a sense of what the agenda holds. I'll be here for the first few minutes, and other than this introduction, I'm going to talk about where things are with COVID. Yes, we're back a bit anyway on COVID. There has been a little bit of an uptick, and we just want to keep tabs on it. Then Kristen Thorsness is with us from the Rochester office, is someone who has a ton of experience in Title IX and otherwise education generally, and is going to be speaking to us about Title IX and transgender athletes. Nihla Sikander is with us from the Albany office, and she's going to be focusing on employer-related matters and pregnancy. Seth Gilbertson, with us from Buffalo, is going to be looking at public employee speech in higher education. I'll be back with you for a walkthrough of cybersecurity and insurance matters. It's a topic that many of you, if you're not thinking about, should be. And then we'll wrap the program up by about 12:45 Eastern. So with that, let's turn to our COVID update, please. And the top of the slide, questions whether it's time to worry. The short answer is, thank goodness, no, it is not really anywhere like it was during the worst of the pandemic. But there are increasing numbers of cases. I can tell you anecdotally, there are pond attorneys who have fallen ill. I was at a wedding over the weekend and a family member unfortunately picked it up. It is back with us. And so the numbers, though, are suggestive of what is a modest increase. I have some of the New York City numbers here on the slide, and we know across the state that it is generally following in the same types of trends, depending on exactly where you are in New York, a little bit more, a little bit less. But again, nothing of the nature that we've seen either in previous last summer in 22 or otherwise. In 21, very different stories relative to where we are right now. And there is every indication that for those of you inclined, vaccinations will be available again in September, a reformulated package, and it is expected further that will all be generally annual on a going forward basis. Various federal approvals have yet to be issued, so nothing certain yet, but that is what we're peering ahead with an eye toward next month, and we'll keep all of you apprised as it may well affect your workplaces too. Let me, with that, turn to our first speaker, who I mentioned is Kristen, who is of counsel out of Rochester. Her career has been a really fascinating one. She actually was an Olympic gold medalist in 1984 as part of the first U.S. women's rowing team ever to win an Olympic gold. She was as well a Division I collegiate rower, and she's won several world championship silver medals. And that was before and otherwise, contemporaneous with, falling in love with the law and spending a considerable amount of her career, as I mentioned, focused on Title IX, athletics regulation, and specifically gender equity in athletics, and has a perspective on the increasing understanding and texture around transgender athletes, and is here to present generally on where things stand presently and what some of you, particularly in higher education, might wish to think about. We think that for all of you, regardless of industry, this will be very much an educational opportunity. So, Kristen, the floor is yours, and thank you so much for joining the program. We know this is your first appearance, but we're hopeful it won't be your last.
Good afternoon, and thank you, Gabe. As Gabe said, I'm joining you today from Bond, Schoeneck King's Rochester, New York office. I'm a member of Bond's education and collegiate sports groups. We serve schools, school districts, and colleges, providing advice and litigation representation on a wide array of topics. As Gabe said, as part of this team, I specialize in Title IX, gender equity, and athletics. I'm here today to talk about the issue of athletic participation by transgender females and how the legal obligations for educational institutions are rapidly changing at both the state and the federal levels. To borrow a line from the talking heads, how did we get here? Well, transgender female athletes have been competing at high levels since the 1970s. You might remember the professional tennis player Renee Richards. But issues of gender and gender identity have increasingly become a topic of national discussion in recent years. Although only a tiny percentage of female athletes are transgender, the question of whether to allow trans females to compete against cis females, that is, athletes who were assigned or were biologically female at birth, figures prominently in the national conversation about women's athletics these days. For example, you may have heard in last year in 2022, when trans female swimmer Leah Thomas gained national headlines when she won an event at the NCAA National Championships. Opponents of trans female athletic participation voice concerns for fairness to cis females on the playing field, asserting that trans females enjoy an unfair advantage in hormone levels, muscle mass, and bone length. They also worry that cis females will have to share showers or hotel rooms with pre-surgical trans females, and have advocated for limiting the use of girls' and women's bathrooms and locker rooms to only cis females. Those supporting inclusion point to the important psychological and social impacts of school sports participation on trans females, who otherwise have shockingly high rates of depression, suicide risk, and diminished academic performance. They also note that many exclusionary rules provide for invasive testing for girls and women whose gender is questioned, including visual examination of genitalia, blood testing, or mandatory disclosure of confidential medical records. For example, in August of 2022, a state championship winning girl in Utah was subjected to gender investigation after the parents of two girls who she beat alleged that she was transgendered. She was not. Some commentators propose creating other or open categories where trans females compete against trans females, non-binary competitors, and males. Opponents to this approach, however, assert that forcing testosterone-suppressed trans females to compete against non-suppressed males would be unfair competitively. Additionally, they argue that such treatment essentially says that trans females are really just males, thereby delegitimizing the trans athlete's gender identity. So, as was inevitable, the courts have become involved in this issue as well. The United States Supreme Court weighed in on the rights of transgendered people in 2020 in an employment law case called Bostock versus Clayton County. Though not directly addressing the issue of transgender athletes, the court ruled that the phrase sex discrimination includes discrimination on the basis of gender identity, among other things. Several federal courts then looked to Bostock in ruling that transgender students were entitled to be treated in a manner consistent with their gender identity, in such things as the use of bathrooms and in both scholastic and intercollegiate athletics. Other courts have reached the opposite conclusion, finding that Bostock's impact is limited only to the employment arena, that Title IX supports biological definitions of sex, and other grounds to preclude trans females from athletic competition on girls' and women's teams. These widely contradictory rulings are, in my opinion, likely to take the issue of trans female athletes to the United States Supreme Court sometime probably in the next couple of years. While all of that was going on, shortly after taking office in 2021, President Biden directed federal agencies to apply the Bostock Rule to all laws barring sex discrimination, not just in the employment realm. Title IX is one such law. For those of you who aren't familiar with it, in short, Title IX prohibits sex harassment and discrimination in all educational programs that receive federal funding. This encompasses almost every elementary, secondary, and collegiate institution nationwide. What happens if you violate Title IX? Well, your school can lose its federal funding. That's a potentially catastrophic penalty, although in reality, it's almost never imposed. Instead, alleged Title IX violations are usually resolved through settlement agreements that are overseen by the United States Department of Education. However, this is a long, complicated, and expensive process, which can often last for years. So it's really not something that you want to engage in unless you absolutely have to. In addition to this action at the federal level, over 20 states have enacted legislation excluding trans females from participation in girls' and women's athletics. Recently, the US House passed a bill on a party line vote, which would define sex for Title IX purposes as reproductive biology at birth and would ban trans females from athletic competition in girls' or women's events. To further complicate things, the NCAA takes a sport-by-sport approach, deferring to the rules of each sport's national governing body, which in turn have taken a variety of approaches. So for example, some sports ban anyone who has gone through male puberty from competing in events for females. Other sports have adopted maximum blood testosterone levels, which allow trans females to compete in women's events subject to hormone level testing and monitoring. Still, other sports allow trans females to compete after a year of testosterone suppression treatment. This leaves colleges and college athletes subject to governing body rule changes that may even occur mid-season and may impact scholarship entitlement. On April 6th of just this year, just a few months ago, pursuant to President Biden's 2021 directive, the Department of Education issued proposed amendments to Title IX's athletics regulations. These proposed regulations, and again, they are proposed at this point, would allow schools to adopt biological sex-based requirements for athletics participation, including some which exclude transgender, intersex, and non-binary athletes, so long as such rules first take into account the nature of the specific sport, the level of competition, and the educational level of the athletes involved. Second, are substantially related to the achievement of an important educational objective. And third, minimize harm to excluded athletes. So for example, broad exclusionary rules at the elementary school level might be found to be contrary to Title IX, while high school and collegiate programs, especially in contact sports or those which highlight muscular strength, might have more leeway to exclude athletes based on their gender at birth. Whether individual athletes did or did not experience male puberty before transition might also impact eligibility. There was a recent court case out of the state of Arizona, a federal court there, who really emphasized this notion of whether or not the athletes had experienced male puberty and therefore enjoyed some of the benefits physiologically that come with that. The comment period on these proposed amendments closed on May 5th and fielded over 132,000 comments, running the gamut of political, social, and religious perspectives. Final regulations are expected sometime this fall and will undoubtedly give rise to even more litigation. So as you can see, the resulting environment for educational institutions is extremely hazardous and confusing. Rather than any bright line rules, schools can find themselves having to choose between complying with conflicting state and federal law, judicial decisions, and sport governing rules. If your school receives federal funds and has an athletics program, I encourage you to have legal counsel take a careful look at how your program complies with current local, state, and federal law in this regard. All of this is changing very quickly, and compliance last year may well not equate with compliance today. So in this rapidly changing environment, solid legal advice is your best protection against litigation and regulatory enforcement actions. That's what I have. Gabe, if there's any questions or any follow-up?
Nothing has come in through the chat just yet, but for those of you in the audience who have questions, feel free to type them in and Kristen will remain with us. Kristen, thank you so much for that really fascinating presentation. Looking forward to having you back on a future program. And now let's turn to our next presenter, who is with us from Albany. Neela has been on previously and is here to talk about pregnancy-related employer-employee matters. It is always worth paying heed to these dynamics. Neela, by the way, is someone who comes to Bond both with training locally in Albany at Albany Law School, where she secured her LLM, and before that trained in Sri Lanka, and so brings that array of perspectives and more to her work in labor and employment matters. So, pardon me, we're thrilled to have you back on the program and looking forward to hearing this presentation. So with that, the floor is yours, and thank you.
Thank you, Gabe. It's great to be back, everyone. It's lovely to speak on in this forum again. So I recently wrote a blog post on what to expect when your employee is expecting. We've all been there. Most of you probably have been there, where an employee has disclosed to you that they're pregnant and need accommodations or need leave and a variety of other issues. So I wanted to kind of provide you with an overview of the federal protections as well as New York State protections that are in place, and talk to you a little bit about the PWFA, which is the Pregnant Workers Fairness Act. Next slide, please, Kathy. Thank you. So to summarize, I'll talk a little bit about the Pregnant Workers Fairness Act, the proposed regulations, as well as the PUMP Act, which is provisions for lactation accommodations. So why is all of this important? An EEOC's infographic informed us that 72% of working women will become pregnant while employed at some time in their lives. So as employers, these are things that you would need to expect predominantly, and you probably deal with this often. First-time pregnant women, typically a significant percentage work until their final month of pregnancies, and 23% of women think about leaving a job due to a lack of reasonable accommodations or fear from discrimination. And ever since these new laws have been enacted, we've received an uptick in questions from employers because employees are asking about it. They come up with some very creative scenarios that you're like, I don't know, I'm going to have to look that up. So I wanted to provide you with just a few insights today in the limited time we have, and then in hopes of kind of assisting you with that process. Next slide, please. So let's talk a little bit about the federal protections that we have in place that you already know about. You know that Title VII of the Civil Rights Act, as amended by the Pregnancy Discrimination Act, covers pregnancy discrimination. So pregnancy discrimination under Title VII can be based on a current pregnancy, a past pregnancy, a potential pregnancy. I've had employers ask, well, what about fertility treatments? Would that be covered? Or infertility treatments? Yes, that would be. Medical conditions related to pregnancy or childbirth, having or choosing not to have an abortion, and birth control, all of those are protected, are covered under pregnancy discrimination. We also have the Americans with Disabilities Act, which prohibits discrimination against applicants or employees based on a disability, including a disability related to a pregnancy, such as diabetes that developed during a pregnancy. So it's important to note, while pregnancy itself is not necessarily a disability under the ADA, some pregnant workers may have impairments that are related to pregnancy that qualify as a disability under the ADA. It talks also about medical kind of records and confidentiality as well. One important thing to note, both the Title VII and the ADA protect working parents and others with caregiving responsibilities for children. We've talked about that before in this forum. I won't touch upon that, but it's important to note that those protections are also in place for working parents and mothers. Next slide, please. So one important kind of development is the Pregnant Workers Fairness Act, which has might not necessarily be much different to us in New York State, because we might have already been complying with some of this, but it does change some of our preconceived thought, understanding of how we need to reasonably accommodate pregnant individuals who are experiencing pregnancy, childbirth, or related medical conditions. A covered employer is considered an employer who has at least 15 employees, but notably, it requires a reasonable accommodation of known limitations related to pregnancy, childbirth, or related medical conditions. There's a lot of nuances there that we kind of have to unpack. Known limitations is very different to what is considered a disability under the ADA. The PWFA requires accommodations for known limitation, which is a physical or mental condition related to, affected by, arising out of pregnancy, childbirth, or related medical conditions that the employee or employee's representative has communicated to the employer. And it does not matter if it meets the definition of disability under the ADA. And I'll talk to you a little bit about, some of the things that are captured within that definition. One other thing that the PWFA also discusses is what is considered a qualified employee. These types of pregnancy and pregnancy-related conditions are considered temporary. So the accommodation is essentially temporary, and an employee or applicant is considered qualified if any inability to perform an essential function is temporary, and the individual can perform that essential function in the near future. And you can actually reasonably accommodate that, sans undue hardship. So there's an aspect of that is more generally applicable to employees as opposed to some of the parameters set by the ADA. One other thing with reasonable accommodations is the PWFA prohibits employers from denying a reasonable accommodation to a qualified individual if you have to go through the interactive process. So, and you cannot require leave if another effective accommodation is available. Sometimes employers state, well, you might be a healthcare worker. I need you to be able to lift patients or transport patients. And if you cannot do that, then I'm going to place you on a paid or unpaid leave of absence. But that you can't automatically do that. You need to go through this interactive process. The PWFA actually specifies that you need to do that. They've also included examples of reasonable accommodations in the workplace for pregnant or recovering employees. So additional break time, reserved parking, flexible work hours, job restructuring, teleworking, all of those are options that are presented for you. Next slide, please. Just a little bit about the proposed regulations. The EEOC opened these proposed regulations for public comment on August 11, 2023. The EEOC must implement final regulations by December 29. Clarifies quite a few items. I want to focus on a couple of things. These are all proposed regulations, but it kind of tells you where the EEOC's head is at with this. The proposed regulations define pregnancy, childbirth, or related medical conditions to include all of the things that we discussed, in that Title VII perspective, but includes current and past pregnancy, potential pregnancy, lactation, use of birth control, menstruation. So if you have, menstrual, you need to take a leave of absence, or you need time off due to menstruation, that is an option that could be covered under this law. Infertility and fertility treatment, stillbirths, miscarriages, and also notably any pre-existing conditions that intensify with pregnancy or childbirth. So instances like anxiety, high blood pressure, carpal tunnel syndrome, the list is non-exhaustive. Interestingly, one thing that we had spoken about before was, well, how temporary is temporary? So the EEOC proposes defining temporary as lasting for a limited time, not permanent, and may extend beyond in the near future. So for near future is defined as 40 weeks from the start of the temporary suspension of an essential function. They're also looking at, tweaking that to 52 weeks. And the start and stop time of what is a temporary suspension of an essential function is also up in the air at this point. Among other things, they've talked about predictable assessments. So de facto accommodations. You kind of need to accommodate them. You don't necessarily need an interactive, individualized assessment here. So if an employee, for example, asks you to, sit versus stand while they work, you might need to kind of consider that. They're also talking about interim reasonable accommodations. This means if an employee is asking you to provide an accommodation while conducting the interactive process, the EEOC contemplates that you actually do provide that accommodation on an interim basis, because they don't want you to, they want you to continue with the interactive process, but they're also saying, well, go ahead and allow that accommodation on an interim basis. They do warn us that employers who do not provide such interim reasonable accommodations or unnecessarily delay the interactive process may, have to may lead to liability. There may be liability. Okay. So there's a bunch of other stuff to go over, but I'd like to really quickly move on to the next slide, please. Thank you, Kathy. Wanted to review lactation accommodations. We've already spoken about you've heard about this before. There is now a federal protection. It's called Providing Urgent Maternal Protections Act, the PUMP Act, and it extends protections for nursing employees. You must, there are some discussions around providing paid breaks if you also provide other employees, other employees are paid for break time. Employees are entitled to space to express other than a bathroom, and that is shielded from view and free from intrusion. But the New York State law goes a little further. Next slide, please. New York State law actually recently introduced a standard policy. You do need to provide that written policy to all employees upon hire, annually, and upon return to work after childbirth. It provides extensive detail on what a lactation room or location should provide. Next slide, please. And a chair, a working surface, access to clear running water, and an electrical outlet. Federal law, but the federal protections also include additional guidance from the Office of Women's Health that you might also want to look at. Next slide, please. So, to wrap up, what are some of the takeaways here? Currently, employers have been reviewing policies and forms. They've been trying to figure out ways to incorporate these regulations and these laws into their policies to ensure compliance. You do need to implement them, and you have to ensure that you treat your employees consistently. If you treat a group of employees a certain way with these requirements, you want to make sure that you're consistent in terms of your practice. And of course, educate and train your supervisors. That's very important because they are kind of the first line of defense that most employers have. I call this RISE because with all of these challenges that we're faced with, we want to rise above it all. Thank you very much for having me, Gabe. I'm happy to answer any questions offline and look forward to speaking with you all. Thank you.
Neetha, thank you so much. Indeed, there are several questions that came in while you were presenting, and I'll leave it to you to address them while Seth is presenting. Really informative material. So thank you for coming on the program and sharing it. And I see Seth has turned on the camera and is ready to present to us. Seth is, of course, a regular on the program out of our Buffalo office where he's senior counsel, and works on matters involving education and labor chiefly. And he's here to talk about public employee speech regulation in higher education. There's been some interesting movement in the space, and Seth has graciously volunteered to catch us all up. So Seth, please go right ahead. Thank you.
Thanks, Gabe. Next slide, please. In order to understand what's happening now, we sort of need to go back in time a little bit and look at how we got to where we are now. The first case I want to just touch on briefly is called Garcetti. It's actually versus what is now the State University of New York. Garcetti and the other plaintiffs in the case, the related plaintiffs, were faculty and librarians at the University of Buffalo, which had just been taken over by the State University of New York. It was previously a private institution. This is in the mid-60s. The case got to the Supreme Court in 1967. And at the time, the state of New York required that all employees sign a pledge of essentially signing cut to the chase, was essentially a pledge saying you're not a communist. Now, interestingly, the Supreme Court had upheld that pledge a few years earlier. And a few years go by, and we get a little bit further from sort of McCarthyism and into the late 60s. The court had evolved a little bit, and you see some of the language here that I think is what I really wanted to point to. And this is this sort of soaring rhetoric about the importance of academic freedom and how it's going to be a protected special concern within the court. I'm not sure how much of a special concern it is now, but clearly academic freedom is still a concern, still an issue in the court. And Kishian really sort of laid that foundation in a lot of ways, and said essentially these faculty and librarians at the University of Buffalo did not have to sign the pledge in order to keep their employment. A year later, then, we get a little bit clearer of a test from the court in what is probably the most famous case in this area for a number of years, and that is the Pickering case, which involved a teacher who had written into a local newspaper to criticize the local Board of Education. And the Board of Education didn't like that very much and took what we would describe as probably retaliatory adverse employment actions against Pickering for having written these critical editorials in a local paper. That case made it up to the Supreme Court, and the Supreme Court essentially said that when evaluating a public employer's actions against an employee for speech-related activity, that the courts needed to balance the rights of the employee as a citizen to speak on matters of public concern with the employer's right to essentially run an efficient and effective workplace. And that test, with some refinement over a number of years, stood in place until 2006. Next slide, please. In 2006, we had another case come up, and this one did not come from education, but came from actually law enforcement. The case is Garcetti, and Garcetti established a new part of the test, essentially, that said, first say Garcetti involved a district attorney who made comments that were critical of local police and how they had come across how they created some warrants, created some tension with the sheriff's department, and Garcetti the employee. Garcetti is actually the name of the district attorney in Los Angeles County at the time. The employee experienced some negative employment actions, didn't get a promotion, was actually demoted, I believe, at some point, and sort of sidelined in his career, brought the claim. And the court decided in that case that when an employee speaks pursuant to their official duties, there is essentially no protection for that speech. It's sort of removed from the ambit of First Amendment protections. That case, while simple in some respects and as applied to many public employees, created particular concerns for faculty of really teachers as well, but for primarily, I think, especially faculty at public institutions, state-supported institutions of higher education, who, as a large part of their official duties, produce scholarship and teaching, which is essentially speech, often on matters of public concern. So, of course, if institutions of public higher education were allowed to retaliate against faculty members when they engaged in scholarship and teaching that the institution didn't like, that would be essentially the definition of academic freedom is what protects that kind of speech. And if you eliminated that, you'd essentially be eliminating academic freedom for all public college and university faculty members everywhere. So because Garcetti was a law enforcement and not a higher education case, the court said, as you'll see here in this quote that I put in the middle there, that basically they didn't have to decide right now how Garcetti would apply to public higher education. And they kicked the can down the road, really kicked it down to the circuit courts to decide. And that's what we've had since 2006, almost 20 years now. Circuit courts dealing with these issues on their own without any real clear further guidance from the Supreme Court. And we have seen many circuit courts sort of take up the Supreme Court's indication here and then further silence on the issue and really have extended additional protection to college and university faculty particularly when they're engaged in scholarship. Now, none of these courts that I note here, 4th, 5th, 6th, and 9th, or the ones that have addressed this issue squarely or close to squarely, have come up with a clear test as to how we're supposed to do this. They've just sort of implied or jumped to the conclusion that Garcetti can't apply or doesn't apply, and then gone on to effectively go through the Pickering balancing test as they would have prior to 2006. Next slide, please. Recently, however, instead of sort of skirting around the issue or avoiding it, the Fourth Circuit said the quiet part out loud, and actually purportedly said that they've repeatedly recognized that the Garcetti rule does not extend to speech by public university faculty members when acting in their official capacity to engage in scholarship or teaching. Now, we went back and looked at those cases. They didn't really repeatedly recognize it clearly. They sort of implied it at one time about 12 years ago. But we'll take them at their word, and what ultimately what the importance of this case isn't, whether they've repeatedly recognized it or not. It's that they clearly are recognizing it now and went a step further and essentially put in place a test that looks at the Garcetti case first and determines whether the speech of the public university faculty member is related to their work, and if so, was that work scholarship or teaching such that it's protected by academic freedom? If it is, then it goes to the Porter-Connick test, and is a matter of public concern. Is the employer's interest more significant? Does it outweigh the employee's interest? So we have this clear test out of the Fourth Circuit, which is a pretty middle of the road circuit in terms of not being extremely liberal like the Ninth Circuit's often viewed, or particularly conservative like the Fifth Circuit is often viewed. It's sort of a middle of the road circuit who's now evaluated this issue a couple of times and now has actually enunciated a test that we can apply. So what's going to happen from here? It's going to be difficult if other circuits start adopting this kind of test for the Supreme Court. Either they're going to have to deal with it or not, now that there is actually sort of this precedent that's clearly squarely in front of them. The Second Circuit has managed somehow over the course of the last almost 17 years to dodge this issue. Are they going to address it? The Second Circuit, of course, covers New York, which is why I bring that up. And there are a few cases that we're watching that may present the issue to the Second Circuit. It'll be interesting to see what they do with that. And in the meantime, what are we supposed to do? If not Garcetti, are we back to a Pickering-Connick sort of balancing test? Are we supposed to apply the Fourth Circuit test in the Second Circuit in the absence of a clear dictate from the Second Circuit as to which precedent we're supposed to apply? I think there are a couple sort of recommendations I'll make here before we finish for the day. First, I think scholarship is going to be defined fairly narrowly. So blog posts, social media commentary, interviews with media, less likely to be deemed scholarship than clear things such as publications in peer-reviewed journals. That's clearly scholarship. It's almost certainly going to continue to be protected under academic freedom and some of the circuit court precedent that we're seeing here. The other thing I think is important, particularly if you are a public university employer trying to enforce some kind of employment-related rule, is to show the effect that the speech has on the institution. In other words, bolster the weight of the weight that you're going to put on the employer side of that balancing test. And I think that's easier to do in the teaching realm than it is in the scholarship realm, and probably easier to do when the scholarship is more in the vein of public commentary, such as blog posts or interviews or editorials or things like that. So those are a few things you're going to look at. I think certainly building that case as an employer, if you're going to take action, is important. And again, focusing on things that aren't pure scholarship, that are purely clearly protected by academic freedom, you're going to have the most likelihood of success in trying to enforce rules that are being applied to either whether it be teachers or college and university faculty. Thank you.
Steph, thank you. Really fascinating, and we'll see whether you read the tea leaves accurately as we all learn more. What I'm going to do is make a real-time programming change. We recognize that it's 15 minutes before the top of the hour, and my presentation is one that we'll hold on. I will be back hosting, though, on September 5th, and I intend to present my content on cybersecurity and related insurance attributes and dynamics at that point. So please tune in then for that presentation. If you are available on the 29th, and we know some of you are going to be taking some vacation and otherwise enjoying the end of summer, please tune in to our next program with Kristen Smith. As I noted, I'll be back on September 5th, right after Labor Day. Looking forward to spending more time with all of you. Thank you for tuning in today, and please enjoy the rest of August. Thank you. Be well.